It's worth noting how dishonestly the media and so-called legal professionals around the world report on this question. They report on it as if Trump's executive order on birthright citizenship is an effort to change the law. I mean, here's Harvard Law School, Harvard Law Today. Can birthright citizenship be changed? Harvard Law School professor Gerald Newman says the president has no authority at all to change United States citizenship rules. And that's true, but here's the thing. Trump isn't changing the rules. Trump is merely recognizing the rules for what they actually are. And all these journalists and all these legal experts, invariably on the left, are lying to you when they try to tell you that Trump is changing the rules. What Trump is doing is refreshing everybody's recollection on what the rules actually are. And the rules, the actual rules, are that birthright citizenship applies only to people who are born on American soil and who are exclusively subject to American jurisdiction, meaning that their parents are exclusively subject to American jurisdiction and have no loyalty to any other sovereign state. So they cannot be illegal invaders of our nation. They have their own nationality, and their child inherits their nationality, even if born on American soil. They cannot be transient visitors, like people here on work visas or student visas or tourist visas, so-called birth tourism. They retain sovereignty, loyalty to their sovereign state. We do have one Supreme Court decision that says birthright citizenship can extend to people whose parents are non-citizens but are permanent resident aliens. I think that's bad law, but in fact, Trump's executive order allows for that. So it doesn't even purport to change that old Supreme Court decision of Wong Kim Ark. We'll take a look at that in a moment. All Trump is doing is correctly clarifying what the law actually is on birthright citizenship. It doesn't apply to just anyone who's born on American soil. That would be a legal doctrine called just solely, the soil, the law of the soil. And that is a legal doctrine that has and can exist in various places. And it would mean that anyone born in a jurisdiction is automatically a citizen of that jurisdiction, no matter what, no matter the citizenship of their parents, no matter what their status is when they're born there, what their parents' status is, just doesn't matter. The soil gives you citizenship. That has never been American law. There's no court that says it's ever been American law. It's not American law today. Although the legal experts will lie to you and will tell you that this Supreme Court case of Wong Kim Ark establishes just solely as American law. It does not. It does not. Wong Kim Ark mentions just solely once in passing in reference to ancient Rome, where it was the rule. But it never says that's now the rule in America. It doesn't say anything of the sort. They just lie and lie and lie. That is what they do. Fortunately, you're here, and here you get the truth. So let's provide some foundational facts on all this. So here's that executive order protecting the meaning and value of American citizenship, and the relevant portion for us reads, by the authority vested in me, blah, 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 blah. Purpose of this executive order. The privilege of United States citizenship is a priceless and profound gift. The 14th Amendment states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That provision rightly repudiates the Supreme Court of the United States' shameful decision in Dred Scott. Dred Scott was the Supreme Court decision that said slaves in America cannot be American citizens. Even freed slaves cannot be American citizens. Later overturned, which misinterpreted the Constitution as permanently excluding people of African descent from eligibility for United States citizenship solely based on their race. And this, by the way, this Dred Scott decision was largely what the 14th Amendment, passed, ratified shortly after the Civil War, was intended to rectify, to provide citizenship to freed slaves. How do we know that? Because the men who wrote and debated and ratified the 14th Amendment tell us so. We're going to look at quotes of their debate in just a moment. Trump's executive order continues, but the 14th Amendment has never been interpreted to extend citizenship universally to everyone simply because they were born within the United States. That's incontestably true. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States, but not subject to the jurisdiction thereof. So that phrase is in quotes here because it's important. It controls the argument here. The executive order continues. Consistent with this understanding, the Congress has further specified through legislation that persons born in the United States and subject to the jurisdiction thereof is a national and citizen of the U.S. That statute just echoes the 14th Amendment's language. And now the relevant part of Trump's executive order. This is where people who thought they might be citizens or their children might be citizens get excluded. Trump's executive order writes, among the categories of individuals born in the United States and not subject to the jurisdiction thereof, and therefore not American citizens under the 14th Amendment, the privilege of United States citizenship does not automatically extend to persons physically born in the U.S. when that person's mother is unlawfully present. She's an illegal migrant, third world invader, and the father's not a U.S. citizen or a lawful permanent resident. So for Trump, it's enough if the father is a lawful permanent resident, even if he's a citizen of some other country. That's what Wong Kim Ark, the Supreme Court decision, provides. I think that's bad law. The 14th Amendment doesn't say anything about that. But nevertheless, Trump's executive order is consistent with Wong Kim Ark, allowing for children of permanent resident aliens, what we call today green card holders, to be citizens by birth, or also excluded when that person's mother's presence in the U.S. at the time of their birth was lawful but temporary, such as, but not limited to, visiting the U.S. under the auspices of a visa waiver program, a student visa, a tourist visa, a work visa, and the father, again, was not a U.S. citizen or lawful permanent resident at the time of the child's birth. Very straightforward. Essentially, if the mother's here unlawfully and the parents are transiently, and the father is not a citizen or permanent resident alien, there is no birthright citizenship. That child inherits the nationality of its parents. And here is the relevant language from the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the U.S. and the state wherein they reside. But here's the catch, folks. Subject to the jurisdiction thereof. Now, there's a couple ways to think about jurisdiction. It has multiple contexts. One is criminal jurisdiction. Criminal jurisdiction simply means that if you're in the U.S. and you commit a crime, can we try you in our courts? And the answer is, of course, unless you have some form of diplomatic immunity, which is unusual. You can be tried for criminal violations in our courts, even if you're incontestably a foreign national. So you come visit the U.S. from France and you rob a bank. Can we try you for robbing the bank? Are you subject to our criminal jurisdiction? The answer is yes. Does that in any way change your nationality? No, you're still a dirty Frenchman. You're subject to our criminal jurisdiction. But of course, you're subject to our criminal jurisdiction simply by being physically present in the U.S. when you commit your crime. It's got nothing to do with your state of nationality. It has to do with being physically present. Are you physically present when you're born in the U.S.? Yeah, of course you are. So you're automatically subject to criminal jurisdiction. So this phrase, subject to the jurisdiction thereof, must mean something other than criminal jurisdiction, or it would be redundant. You don't need it. If all this phrase meant was you're subject to the criminal jurisdiction of the U.S., simply being physically present is enough for that. It would simply read, all persons born in the U.S. are citizens of the U.S. But it doesn't read that. It adds that phrase, subject to the jurisdiction thereof. So jurisdiction here means something more than criminal jurisdiction. And as we'll see, what it means is political jurisdiction, which is different. And even more to the point, it means exclusive political jurisdiction. How do we know? Because the men who wrote, debated, and ratified the 14th Amendment told us so in their debates. And we have their debates in the congressional record, what's called at the time the Congressional Globe. Let's take a look at some of the senators, and these are senators who ratified this, at some of the senators and what they had to say about the 14th Amendment and the subject of jurisdiction. Senator Howard This 14th Amendment, which I've offered, is simply declaratory of what I regard as the law of the land already, that every person born within the limits of the U.S. and subject to their jurisdiction is a citizen of the United States. All right, fair enough. That's the language of the 14th Amendment. And then he points out that although Indians, Native American Indians, are born within the limits of the United States, they are not citizens because they maintain their tribal relations. If they maintain their tribal relations, they are not subject to the jurisdiction of the United States. So he's distinguishing between being born here and where your loyalty to a sovereign is. Their loyalty is to their tribe. Therefore, they are not subject to the jurisdiction, the political jurisdiction of the United States. If they murder someone, can they still be tried in American court? Absolutely. So they're subject to our criminal jurisdiction, but they're not subject to our political jurisdiction. They don't get to vote, for example. Their loyalty in terms of sovereignty is to their tribe, not to the United States. Senator Cohen, it's perfectly clear that the mere fact that a man is born in the country has not heretofore entitled him to the right to exercise political power. There's no political sovereignty just because you're born here. Senator Trumbull, the provision is that all persons born in the U.S. and subject to the jurisdiction thereof are citizens. That means subject to the complete jurisdiction thereof. What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That's what it means. It's hard to get any clearer than that. And by the way, folks, you'll just have to trust me because I don't want to read through the whole record. There was no counter argument. All the quotes I'm showing you from the men who debated and ratified the 14th Amendment were uncontested. This was universally accepted by them. And of course, the amendment has the meaning they intended it to have at the time they ratified. Senator Trumbull again, it cannot be said of any Indian, Native American Indian, who owes allegiance, partial allegiance, if you please, to some other government, their tribe, that he is, quote, subject to the jurisdiction of the United States. It is only those persons who come completely within our jurisdiction, our political jurisdiction, who are subject to our laws that we think of making citizens. Senator Trumbull again, I have already replied to the suggestion as to the Indians being subject to our jurisdiction. They are not subject to our jurisdiction in the sense of owing allegiance to the United States, and they would not be embraced by this 14th Amendment. Even though clearly, indisputably, they are born within the borders of the U.S. and they are subject to our criminal jurisdiction, they are not subject to our political jurisdiction. Do not owe allegiance solely to the United States. Senator Johnson, now all this 14th Amendment provides is that all persons born in the United States and not subject to some foreign power, they're not a foreign national. For that, no doubt, is the meaning of the committee who've brought this amendment before us. Only those people not subject to some foreign power shall be considered as citizens of the United States. Senator Howard, I concur entirely with the honorable senator from Illinois in holding that the word jurisdiction, as here employed, ought to be construed so as to imply a full and complete jurisdiction on the part of the United States. Certainly, gentlemen cannot contend that a Native American Indian belonging to a tribe, although born within the limits of a state, is subject to this full and complete jurisdiction. That question has long since been adjudicated so far as the usage of the government is concerned. Senator Williams, in one sense, all persons born within the geographical limits of the United States are subject to the jurisdiction of the United States, the criminal jurisdiction, but they are not subject to the jurisdiction of the United States in every sense. Take the child of an ambassador as one example. In one sense, the child's born in the United States and is subject to the jurisdiction of the United States because that child, if that child commits a crime of murder or commits any other crime against the laws of the country, to a certain extent, he's subject to the criminal jurisdiction of the United States, but not in every respect. I understand the words here, subject to the jurisdiction of the United States, to mean fully and completely subject to the jurisdiction of the United States. No shared nationality. Senator Salisbury, I do not presume that anyone will pretend to disguise the fact that the object of this amendment is simply to declare that freed slaves shall be citizens of the United States. That's all they meant to cover. And then we get to this case from 1898, Wong Kim Ark from the Supreme Court. Very widely misreported. They tell us exactly what the legal question is here. This is their conclusion of this lengthy decision. The evident intention, this is quoting the Supreme Court in Wong Kim Ark, the evident intention and the necessary effect of the submission of this case to the Supreme Court upon the facts agreed by the parties were to present for determination the single question stated at the beginning of this opinion, namely, whether a child born in the United States of parent of Chinese descent, the parents were Chinese nationals, who at the time of their birth were subjects of the Emperor of China, but have a permanent domicile and residence in the United States, and are there carrying on business, and are not employed in any diplomatic or official capacity, and they weren't, whether that child becomes at the time of his birth a citizen of the United States, for the reasons above stated, this Supreme Court, is of the opinion that the question must be answered in the affirmative. Yes, but that yes is contingent on these specific facts. One of the facts that's unstated, by the way, is that these Chinese parents were in the U.S. lawfully. When they left the U.S., they were able to come through customs and return to the U.S. They were permanent resident aliens. They were not invaders, and they were not here transiently. They were permanently domiciled in the U.S. So to the extent that Wong Kim Ark covers anything, it only covers people who bear a child on U.S. soil, who are here legally and permanently, what we would call green card holders. These people are covered by Trump's executive order, meaning he doesn't change anything for them. He says that if the father is here as a citizen or permanent resident alien, his child's an American citizen by birth. So President Trump's is consistent with Wong Kim Ark. Now, I would argue that Wong Kim Ark is bad law because the 14th Amendment doesn't say anything about permanent resident aliens of people who are non-citizens. But even if you decide Wong Kim Ark should not be reversed, it's still limited to the facts of this case. People lawfully present, permanently here, not transiently here. Now, Wong Kim Ark does say a lot of other stuff. So it can get kind of confusing. You can find words in there that seem to define birthright citizenship more broadly. But here's the thing. All the words they say that are not limited to the facts of the case, as they set them out in their own conclusion, are what are called dicta in the law, obiter dicta, passing remarks. And obiter dicta is language in a decision that's not central to the core finding of the decision, and it's considered not controlling precedent. It does not have legal authority. And the reason for that is actually described in Wong Kim Ark itself. They quote the famous Supreme Court first Chief Justice of the Supreme Court Marshall because he talks about this. And Wong Kim Ark, the Supreme Court, talks about this issue of dicta and how you shouldn't be giving legal authority to any discussion that has nothing to do with the core holding of the case. The Supreme Court in Wong Kim Ark says, in weighing a remark uttered under such circumstances, meaning in passing, not necessary to the court decision, it's well to bear in mind the often quoted words of Chief Justice Marshall. What did Chief Justice Marshall have to tell us about dicta? He said, it's a maxim not to be disregarded that general expressions in every opinion are to be taken in connection with the case in which those expressions are used, the specific facts of that case. If they go beyond the facts of that case, they may be respected, but ought not to control the judgment in a subsequent case when the very point is presented for decision. The reason for this is obvious. The question actually before the court, the specific facts of that case, is investigated with care and considered in its full extent. Other principles, which may serve to illustrate it, are considered in the relation to the case decided, but their possible bearing on all other cases is seldom completely investigated. So that's dictum. One more thing on Wong Kim Ark before I jump in. So this is a website. This is a website here. Here we go. Oh, yes. Supreme Court resources. So it's considered an authoritative guide to Supreme Court decisions. And what they helpfully do is they provide a summary. Before you dig into the legalese of the decision, they provide a summary. The facts of the case, the legal question to be answered, and the conclusion. And these people will effing lie to you. They will lie to your face. I mentioned this before. Conclusion. By the way, the question they state correctly, right? Is a child who was born in the United States to Chinese citizen parents who are lawful permanent residents of the US, is that child a citizen under the 14th Amendment Citizenship Clause? Conclusion. This is where they lie to you. And unless you actually understand this stuff, you can't even see the lie. Their conclusion, which is a lie, is that because Wong was born in the US and his parents were not diplomatic officers, the Citizenship Clause of the 14th Amendment automatically makes him a U.S. citizen. Is that what the court said? Is that specific to the facts of this case? Did they not just leave out the critical issues that the parents were legally present and were permanently domiciled? Justice Horace Gray authored the opinion, on behalf of the 6-2 majority, in which the Supreme Court established the parameters of the concept known as jus soli, the citizenship of children born in the United States to non-citizens. Wong Kim Ark never applies the doctrine of jus soli to Wong Kim Ark. They mention it in passing as dicta. This is how the Romans used to do it. They don't say it's American law. They don't say that's why. We just read their conclusion. We just read it. Their finding of law in that case, they don't mention the words jus soli anywhere in it. These people suck. It drives me mad. Because anyone who's not informed about the law, doesn't have the benefit of this community, who read that summary would go, oh yeah, Trump's wrong. Trump's not wrong, my friends. If anything, his executive order is broader than I would like it to be.